It's amazing how much buzz U.S. real estate generates, globally. And you hear this idea all the time that you absolutely have to be a U.S. citizen to buy property here.
Right, that's a really common misconception.
Okay, let's just tackle that right away because it's fundamental. That's simply not true. You definitely don't need U.S. citizenship or even residency to purchase property in the States.
Exactly. It's a key point to get across right at the start. The market's actually much more accessible than people often think.
And look, while it's true foreign buyers are a smaller slice compared to domestic ones, the numbers aren't trivial. We're talking about $42 billion spent by foreign buyers on U.S. residential property just between April 2023 and March 2024.
$42 billion is a significant amount of investment, no question.
But here's the context, right? That $42 billion, it's only about 1.3% of all the existing home sales during that time. So yes, there's global interest, but it's a specific niche. Makes you wonder why it isn't higher, given the interest.
That's a good question. I mean, the legal door is open, but you have practical hurdles. Things like getting financing as a non-resident, figuring out the pretty complex U.S. tax laws. And now, increasingly, you've got these state-level restrictions popping up. All that likely keeps that percentage, relatively modest. Still, $42 billion shows the appeal is definitely there for many.
So who are these buyers primarily? Well, a few countries really dominate the non-resident buyer list. Canada, China, Mexico, and India. They're the big players.
Yeah, those four consistently top the charts.
It's interesting why those specific countries, maybe it's proximity for Canada and Mexico, strong economic ties, established immigrant communities.
It's likely a mix of all those things. Yeah. Canada, obviously, there's the geography and economic integration. China and India, you might see more focus on investment diversification, maybe finding a safe haven for capital. The reasons are probably quite varied.
Right. So that brings us to what we really want to do here today. We want to unpack the realities of buying U.S. property as a non-citizen. We'll look at exactly who can buy, what's involved in the process, and, importantly, some of the big shifts happening right now.
And it's a really relevant time to do this deep dive, given how much the legal and political situation seems to be, evolving.
Oh.
If you're considering this, understanding these details is more critical than ever.
Okay, let's hit that core question again, just to be crystal clear. Can a non-resident actually buy a house in the U.S.?
And the answer is a clear yes.
A firm yes. It is legally permissible for almost any non-U.S. citizen. That includes permanent residents, people here on temporary visas, non-residents living abroad, refugees, asylum seekers, even DACA recipients.
Yes, the principle of property ownership is pretty broad here, legally speaking. It's not tied directly to citizenship status in most cases.
It is important to note, though, while that's the law right now, there has been talk about potential future changes, particularly under the Trump administration, so it's an area to watch.
That's a crucial caveat. Changes in immigration policy, even if they don't directly target property ownership, could definitely have ripple effects on this market.
We actually have a quote here from Jen Horner, a realtor, who puts it very plainly. Purchasing a residential property in the U.S. is open to any individual, regardless of their citizenship.
Yeah, hearing that from someone on the ground, dealing with transactions daily, really confirms the legal principle in practice.
And it's not just who can buy, right? It's also what they can buy. There are basically no federal limits on the type of property. Condos, single-family homes, townhouses, even empty land. It's all potentially on the table.
That flexibility is significant. It caters to all sorts of different needs and investment goals for international buyers.
We also heard from Chase Michaels at Compass. He pointed out this applies both to resident foreign nationals, maybe someone here working on a visa buying their primary home, and also to non-resident foreign investors buying purely for investment or, say, a vacation home.
Right, that distinction highlights the different motivations. Some are buying to live here, others purely as an asset or for occasional use.
And it seems detached single-family homes and townhouses are the most popular choices. Something like 76% of foreign buyers go for those. And get this, about 45% are buying specifically for vacation use or as a rental property or maybe a bit of both.
That shows a real blend of lifestyle purchases and pure investment strategies among these buyers. The single-family preference is interesting too.
Okay, so we've established they can buy. But what about the nuts and bolts, the paperwork? It sounds like non-citizen buyers generally need to brace themselves for more documentation than U.S. citizens. Why is that?
It mainly comes down to verification.
Yeah.
Lenders, title companies, government agencies, they need to confirm identity and financial standing across international borders. That just requires more digging, more proof.
Right. So Chase Michaels mentioned some common requirements, things like a foreign passport, maybe a U.S. visa if you have one, or even a driver's license.
Standard ID, essentially.
And then, crucially, either a social security number if they have one, or an individual taxpayer identification number, an ITN. That's for people earning U.S. income, but who don't qualify for a social security number, right?
Exactly. The ITN is key for tax compliance if you have U.S. income as a non-resident.
They might also need financial statements from their banks back home, proof of assets, proof of income, bank statements, things like that, and maybe U.S. tax returns if they've filed them before.
Basically, building that financial picture for U.S. entities when the history is largely international takes more paperwork.
Now, there's a specific rule about cash purchases.
Yeah.
If you pay over $10,000 in cash, that has to be reported to the IRS, and you'll need to show ID. Why that specific rule?
That's a standard anti-money laundering measure. That $10,000 cash reporting threshold applies broadly across many types of transactions in the U.S., not just real estate.
Jen Horner also flagged this, saying cash purchases will require proof of identity and reporting the purchase to the federal government. So definitely something to keep in mind for cash buyers. And if you're going for a mortgage, expect the lender to ask for a lot of documentation.
Oh, absolutely. Mortgage lenders are taking on risk, so their due diligence is naturally more extensive, especially with international financials involved.
Which brings us to financing. Can non-residents actually get a mortgage? Yes, they can, but it sounds, well, significantly more complex than for a citizen. What makes it trickier?
Again, it's mostly about verification and risk assessment for the lender, establishing a U.S. credit history, verifying foreign income and assets. It's just more hurdles to clear.
So if you're a non-resident seeking a mortgage, you should probably expect more detailed application questions, maybe a larger down payment requirement.
That's very common, yes. Higher down payments are often required to offset the perceived higher risk.
And then once you own the place, you've got to deal with U.S. tax laws, which can be more complicated for foreign owners.
Absolutely vital to understand those tax obligations. Getting advice from a tax professional who specializes in international U.S. property ownership is usually a very good idea.
It seems lenders generally prefer applicants who are actually living in the U.S., either permanent residents, with a green card and social security number, or even non-permanent residents who have an SSN but maybe not a green card yet. Why this preference?
It often boils down to perceived risk. Someone living and working in the U.S. usually has more easily verifiable U.S.-based financial ties, income streams, credit history. Lenders might see that as lower default risk compared to someone entirely based overseas.
So if you're listening and maybe you're a permanent resident with that green card and SSN.
Well, if you have established credit and work history here, you often qualify for the same kinds of mortgages as citizens' conventional loans, backed by Fannie Mae or Freddie Mac, maybe even FHA loans. Chase Michaels mentioned banks offer these if they can verify everything properly.
Okay, but what about non-permanent residents or those living completely outside the U.S.?
For them, the main route is typically through what are called foreign national loans, or foreign national mortgage loans. These are specifically designed for people living abroad buying U.S. property. They aren't backed by Fannie or Freddie, so they operate under different rules.
Got it. So different products, likely different terms, maybe different rates and down payments compared to standard domestic loans.
Exactly. They cater to that specific international buyer segment.
Beyond just buying and financing, what other rules should non-U.S. citizens know about owning U.S. property? Taxes seem like a big one.
Oh, yes. Owning property here means tax obligations regardless of your citizenship.
Like if you rent the property out, that rental income needs to be reported and taxed here in the U.S., and potentially it could be taxed back in your home country, too. It sounds like double trouble.
It can be. That's where tax treaties between the U.S. and other countries become really important. Understanding those agreements is key to avoid or mitigate double taxation. Again, professional advice is crucial.
And just like any U.S. homeowner, you're on the hook for local property taxes.
Absolutely. Property taxes fund local schools, roads, services. Everyone pays them.
And then when you eventually sell the property, capital gains taxes generally apply too, right? Any profit you make could be taxed.
Correct. Capital gains on the appreciation of the asset, including real estate, are typically taxable income in the U.S., regardless of the seller's citizenship.
Bruce Alien, a real estate attorney, specifically warned about special withholding provisions when a non-resident sells U.S. property. He strongly urges consulting an international tax advisor. What's this withholding about?
It's called FRPTI, the Foreign Investment in Real Property Tax Act. Basically, it requires a portion of the sale proceeds to be withheld and sent to the IRS to ensure any potential capital gains tax owed by the foreign seller gets paid. It's a compliance mechanism. Navigating FRPTI definitely requires expert help.
Good to know. And importantly, all the standard U.S. fair housing laws and anti-discrimination protections apply just the same when non-U.S. citizens are involved in buying, selling, or renting.
Yes, absolutely. National origin is a protected characteristic under the Fair Housing Act. Equal opportunity is mandated.
Okay, let's shift gears a bit and talk about some more recent legal stuff that's really changing the landscape. There's this growing focus on national security concerns, especially around foreign purchases near sensitive sites, military bases, key airports, seaports, even agricultural land related to food security. Why is this heating up now?
It reflects a heightened governmental awareness, really, about potential risks linked to foreign control of strategically important land or assets, particularly assets located near critical infrastructure or military installations.
And this brings CFIUS into the conversation, the Committee on Foreign Investment in the United States. They're the government body that reviews foreign investments, including some real estate deals, for national security risks. Sort of a gatekeeper.
That's a good way to put it. CFIUS scrutinizes transactions where foreign entities might gain control or certain rights over U.S. assets that could potentially be leveraged in a way that harms national security.
Their real estate rules focus on deals where a foreign person gets certain rights, like physical access, the power to exclude others, the right to develop the land, or attach structures. And often, the scrutiny is highest near those sensitive locations. Can you give an example of how those rights matter?
Sure. Imagine a foreign company buys land right next to a naval base. If the deal gives them the right to build coal structures and control who comes and goes, CFIUS might worry about potential surveillance or interference with base operations. It's those specific rights granted in the deal that trigger CFIUS jurisdiction.
And CFIUS can actually look back at deals years later, even if they weren't initially notified.
Wow. Yes, they have what's called non-notified review authority. It means if a transaction flew under the radar but later raises concerns, CFIUS can still investigate it. It underscores how seriously they take this.
Now, alongside this federal activity, we're seeing a huge surge in state-level laws restricting foreign land ownership. More than half the states have some kind of restriction now, many passed just in 2023. What's driving this at the state level?
It seems to be a mix, partly mirroring those national security concerns, but also maybe more localized anxieties about foreign control over farmland, water resources, or just the impact on local economies and communities.
And these state laws are all over the map, right? Some are outright bans for certain countries or types of land. Others are just reporting requirements. States like Alabama, Arkansas, Florida, Idaho, Texas, a whole bunch have laws now. So you really need to check the specific state you're interested in.
Absolutely critical. You cannot assume the rules are the same everywhere. The patchwork nature of these state laws means due diligence on a state-by-state basis is essential for any foreign investor.
And several states, like Florida, Texas, Alabama, Iowa, now require specific disclosure of foreign real estate acquisitions, kind of like the federal AFIDA rule we'll touch on, so potentially double reporting.
Right. These state disclosures aim for more transparency at the local level, letting states track who owns what within their borders.
Texas, for example, blocks deals giving access to critical infrastructure properties to entities tied to China, Iran, North Korea, or Russia. Very targeted.
Yes, that Texas law is a prime example of focusing restrictions on specific countries deemed adversaries and specific types of sensitive property.
We all saw the Fufeng Group controversy near Grand Forks Air Force Base in North Dakota. That proposed Chinese-owned corn mill. It was ultimately blocked locally, but national security fears, the proximity to the base, the company's ties to the Chinese Communist Party that really fueled the opposition.
That Fufeng case really crystallized these concerns for the public and policymakers. It became a major flashpoint, highlighting the tensions between foreign investment and national security, especially near military sites.
Alabama passed a Property Protection Act banning foreign principals from China, Iran, North Korea, Russia, and other sanctioned countries from buying agricultural land or any property within 10 miles of military bases or critical infrastructure. That's pretty broad.
It is. Alabama took a wide approach, covering both farmland and proximity to infrastructure, signaling a broad security concern.
Missouri has an executive order doing something similar, banning agricultural land purchases within 10 miles of key military sites by individuals or businesses from foreign adversaries, listing China, Cuba, Iran, North Korea, Russia, and Venezuela. but they explicitly said it shouldn't hurt partnerships with allies, a balancing act there.
Exactly. Missouri tried to target specific perceived threats while explicitly protecting relationships with friendly nations, showing the nuances involved.
And in Arkansas, they actually ordered a Chinese-owned seed company, Northrop King, to sell its land and fine them for not reporting the foreign ownership. So these laws have teeth.
But Arkansas enforcement action sent a clear message. Failure to comply with these reporting rules can have serious consequences, including forced divestment.
Meanwhile, back at the federal level, CFI US added 8 more military bases to its list of sensitive locations for real estate reviews in late 2023, including Grand Forks, interestingly enough.
Seems like a direct response to cases like Fufeng, strengthening oversight around key military installations.
And looking forward, there seems to be a push in Congress to give CFI US clear authority to review farmland purchases specifically, citing food security concerns. A government report in early 2024 pointed out weaknesses in how we track foreign ag land ownership, and the Air Force apparently even has a playbook for assessing these risks now.
Food security is definitely emerging as a major new dimension in this national security discussion around foreign land ownership. The GAO report highlighted the need for much better data.
Now, there already is a federal law, AFIDA, the Agricultural Foreign Investment Disclosure Act, that requires foreign persons with interests in U.S. farmland to report it to the USDA.
Right, AFID has been the main tool for tracking this for decades.
And the USDA is actually proposing updates to AFIDA now, trying to get more detailed info like precise map locations and data on who's leasing the land long-term, trying to get a clearer picture.
Those proposed updates suggest USDA recognizes the need for better data quality and granularity to really understand the extent and nature of foreign holdings.
But that same GAO report found major problems with how USDA currently collects and uses AFIDA data. Things like using old paper forms, slow data sharing, complex rules leading to errors, missing information, potentially meaning foreign ownership is seriously underreported.
Yeah, the GAO flagged significant weaknesses, outdated systems, data gaps, inconsistencies. It all raises questions about the accuracy of the current picture of foreign ag land ownership.
And apparently USDA didn't even assess penalties for failing to report between 2015 and 2018. That doesn't help compliance.
Right. Lack of enforcement definitely weakens the incentive for timely and accurate reporting.
So the big takeaway here seems to be, if you're involved in any U.S. real estate deal involving foreign ownership or control, you absolutely must check both federal rules like CFI US and AFIDA and the specific laws in the state where the property is located. It's way more complicated now.
Absolutely. Due diligence is non-negotiable. The regulatory landscape is complex and shifting, so understanding all the layers is crucial for everyone involved: buyers, sellers, agents, lenders.
Okay, now let's pivot to another big factor affecting foreign buyers: the impact of Trump administration immigration policies. It seems pretty clear that tighter immigration rules could dampen demand from people buying with plans to actually move here, retire here, or just set up a U.S. base. Especially maybe buyers from Asia, Latin America, the Middle East.
There's a definite link. I mean, if getting or keeping a visa becomes harder, or if the general climate feels less welcoming, the appeal of buying a primary home or even a long-term second home here naturally decreases for many foreign nationals.
And things like visa restrictions, whether for students, tech workers, even tourists, they limit mobility. If it's harder to just come and go, it makes owning U.S. property, maybe a second home or a rental you need to manage, less practical or attractive.
Exactly. Owning property often implies needing access to it. If travel becomes difficult or uncertain due to visa issues, it directly impacts the investment rationale for many buyers.
And the strained U.S.-China relationship, plus that tougher CFI U.S. scrutiny we talked about, that could continue to push Chinese buyers away. And that would likely be felt in major markets like LA, New York, Miami, where Chinese investment has historically been very strong.
Given the sheer volume of past Chinese investment, any significant drop-off certainly impacts price dynamics and overall activity in those key gateway cities.
CFI U.S. expansion also adds what many see as red tape, especially for investors from countries viewed as strategic rivals. It can mean longer waits, more uncertainty, maybe deals falling through, particularly for bigger commercial or urban projects.
That added layer of review introduces risk and potential delays, which can be a deterrent, especially for complex, high-value transactions where timing is critical.
And remember, tariffs and trade disputes. Those can drive up construction costs, which might make foreign developers think twice about launching new projects here.
Higher input costs directly squeeze profit margins on development deals, potentially making other global markets look more attractive for new construction investment.
No, it's not all potentially negative, right? There could be upsides, maybe a more favorable tax climate for foreign corporations investing in commercial or industrial property. And those opportunity zones still offer tax breaks that could attract certain investors.
Yes, targeted tax incentives can definitely still be a powerful draw for specific types of foreign investment in certain sectors or designated areas.
What about the dollar? A strong US dollar, often a policy aim, can make US property look more expensive to buyers using weaker currencies, say from emerging markets.
True, exchange rates are a big factor in affordability.
But maybe it doesn't deter the ultra-wealthy who are primarily focused on capital preservation in what they see as a stable market.
For high net worth individuals prioritizing safety and stability, the currency issue might be secondary to the perceived security of U.S. assets. It's a mixed bag.
And then there's just the perception of political risk. Could the overall policy direction make the U.S. seem less stable or welcoming to some investors?
Perceptions definitely matter in global investment flows.
Though, ironically, for people coming from really unstable countries, the U.S. might still look like the safest port in a storm, regardless of policy shifts here.
That's also true. Relative stability is key. The U.S. often remains attractive, even with domestic policy debates, compared to regions with more significant political turmoil.
Miami seems like a really potent example of all this playing out. Stricter immigration talk and policies seem to be putting a chill on its real estate market, which is historically so dependent on foreign buyers, especially from Latin America. We're hearing about falling sales, falling rents.
Miami is uniquely sensitive. Its high concentration of foreign-born residents and reliance on international capital mean immigration policy shifts hit harder and faster there than in many other U.S. markets.
We heard from Maruja Gill, a Miami agent, who said buyers and renters are genuinely afraid because they're uncertain about getting visas extended or approved. That's a direct impact on decision-making.
That anecdote really brings home the human element and the real-world anxiety these policies can create, directly influencing the housing market.
And the numbers seem to show it. Miami home sales reportedly dropping faster than the national average, properties sitting longer on the market. Even rents for typical one-bedroom apartments took a noticeable dip.
Those are classic signs of a cooling market, consistent with a pullback in demand, potentially linked to these immigration concerns.
Plus, Florida has its own state-level immigration crackdowns, which probably adds another layer of concern for non-citizens there.
Right, when state enforcement mirrors or even intensifies federal policies, it can amplify the chilling effect within that specific state.
Some agents in Miami's luxury high-rise sector are apparently saying the majority of their foreign clients have just scrapped their buying plans for now, citing immigration worries. That's a huge shift at the high end.
A pullback of that magnitude in the luxury segment signals a serious loss of confidence among those high-net-worth international buyers, at least temporarily.
And some non-permanent residents are apparently even thinking about selling their U.S. properties and buying elsewhere, maybe Europe or back in Latin America.
That suggests a potential redirection of international capital away from the U.S. market towards places perceived as more welcoming or stable for them right now.
We're also seeing a big slowdown in foreigners applying for those EB-5 investor visas, the ones requiring a big investment, like over $1 million for a green card. People seem to be just stepping back and waiting.
Yeah, the uncertainty is clearly affecting even those major investment decisions tied directly to immigration pathways. People are hesitant to commit large sums when the rules feel unstable.
Peggy Yulin from One World Properties mentioned clients specifically from France and Mexico getting cold feet on deals because of these immigration rule concerns.
Again, concrete examples showing this isn't just theoretical, it's impacting deals with buyers from diverse, traditionally strong markets.
And it's even trickling down to rentals. Some landlords are now reportedly asking for proof of U.S. citizenship or long-term visas before renting. That wasn't always the case.
That's a significant shift in practice. It reflects a heightened caution, maybe even fear, among property owners. And it could create real barriers for